And as I said, some of this is going to be reviewed. So in terms of the crafting of the Constitution, we know that a big part of what was written into the Constitution was based on compromises. Because there were a couple of controversies, both of them relating to equality in different ways. So controversy A, and let's start with kind of the basis for some of the thinking about why equality mattered. There's something that is often referred to as the American Creed. There are different notions of the American Creed for different contexts. For this one, for this class, it is the idea that all people are created equal in their rights, which is something we see from John Locke, reiterated by Thomas Jefferson, and that government is created by the consent of those equal people who are to be governed.
Just a reminder, teachers, there is job embedded in the conference room in the library. It is required to stop by. Thank you.
Okay. Those equal people create government by their consent to protect their rights. Now, for them to be protected and for their consent to be meaningful, the idea is that there needs to be equality in terms of how they are represented and protected by that government. And this ties in because the United States is a republic, meaning it's a representative democracy. And in representative democracies, people signify their consent by electing representatives to make government policy on their behalf. Yes. Oh, yes. Now remember, it's not that we don't have consent of the governed in direct democracies, but in direct democracies, because the people are making the government policy themselves, we don't have this extra step for consent of the governed. In a republic, you show your consent by voting for representatives to make that policy for you. So if equal people have to give consent, how do we try to represent them in an equal way? And for the early United States, it's not just about people. It's also about representation for the states, which still comes up certainly today in U.S. politics. But remember that the early United States, citizens' loyalty was often, if not typically, stronger for their state than it was for the nation as a whole. People think about the United States as a plural label, not as just a label for a unified country. And we were just coming out of, working to replace the Articles of Confederation, in which states were, in most respects, sovereign. And so people cared a lot about how their states would be represented. And this is where things should get more familiar for us. We had competing plans for how that representation would be worked out. William Patterson provided the New Jersey plan, which is going to look a lot like the Articles of Confederation. The national government will be stronger than it was under the Articles of Confederation. It's going to have those key tax and trade regulating policies. but it's still going to be a pretty weak national government. Again, it's going to add in the tax and interstate trade powers that had been missing. But in a lot of ways, that's it. Like the Articles of Confederation government, there is going to be a unicameral legislature, meaning a legislature with one chamber or one house. And also like the Articles of Confederation, in that legislature, the states will all be represented equally. The executive would not be, executive power would not be placed in the hands of one person. We would continue to have kind of plural executive, whose members would be selected by Congress. The way congressional committees had provided executive functions in the Articles of Confederation. And the executive would not serve a fixed term because they could be also removed by Congress. The judiciary would be a little bit different compared to the Articles of Confederation. The plural executive would appoint the judges to serve in the judiciary. Oops, did not mean to jump that quickly. So the executive would have more, at least somewhat, be a more active position than it was under the Articles. But this is certainly not the kind of clear-cut separation of powers system that we ultimately get. And as its counterpoint, of course, we have the Virginia Plan, which was authored by James Madison. This is a much more dramatic departure from the Articles of Confederation. This is going to be a national government that has a lot of strength. In the plan, the superiority of the national government to the states is clearly articulated. I mean, to the point that the national government can take over the operation and the government functions of a state if it decides it needs to. So, very much strong national government. This will have three clearly distinct and separate branches. And for this, remember that connection between Montesquieu and Madison. Montesquieu preaches on the virtues of separation of powers as a way to provide checks and balances, to keep government limited, and to prevent majorities from running wild. And Madison shares the same concerns as Montesquieu and adopts the same solution. And as we talk about separation of powers and checks and balances, we need to be careful not to confuse them. Separation of powers precedes checks and balances. If you do not have branches with their own separate powers and distinct functions, you cannot have a system of checks and balances where they're able to balance the power of each other by having checks on what each branch can do. And that's going to be something you will learn more about in the textbook notes part of what we do today. But under the Virginia plan, and we still have a key difference from the Constitution we ultimately get. Congress will still have the appointment powers to choose who will lead the executive branch and who will serve in the judicial branch at the national level. With this, though, be clear, this is not something that Madison is doing because he wants to carry something over from the Articles of Confederation just for the sake of tradition or nostalgia. Madison is very much afraid of majority tyranny. Remember the violence of faction that we learned about earlier, especially in our Halloween in-class exercise. For him, having Congress choose the leaders of the executive and judicial branches rather than, for example, having people like the citizens vote for the executive is a way of preventing that violence of faction or tyranny of the majority. And another key difference with the New Jersey plan, Congress will be bicameral, meaning 2 houses, 2 chambers. And in both chambers, representation is going to be based on population. And I know this is the part of the plan, especially when you guys did your political cartoons. I know that you are more familiar with this part. There was an alternative. This one often gets forgotten, although I know quite a few groups did include this in their political cartoons. Representation would be based on population, or it could have been based on how much tax revenue a state provided to the national government. The 2 houses were not exactly identical in their arrangements. While they were both based on population or taxes, the lower house, the lower chamber or the house would be elected directly by the citizens. And then members of the Senate or upper chamber would be chosen by members of the House. And the House would have to choose members of the Senate from lists of candidates provided by the legislatures of the states. Okay, so the House just can't pick anyone they want to serve in the Senate. Because as originally intended, even including in the ultimate version of the Constitution that we get, there was concern that the states themselves actually have representation. And that's what the Senate was supposed to provide. There are lots of disagreements over things like the power of the new national government, but the most intense conflict is over how representation would be determined. Would it be proportional, as in the Virginia plan, or would it be based on a strict equality of principle for the states, as in the New Jersey plan? Naturally, small population states favored the New Jersey plan, and because it would maintain their representational power in the legislature. Large states with, and here we do need to be clear, we're talking about large population states. I know most of you will get that, but sometimes it's hard not to think about an image of a map of the United States and think about it in terms of territory. The compromise, of course, comes in the Connecticut Compromise, sometimes known as the Great Compromise. And the primary author of that is Roger Sherman. Who is this guy? And he clearly looks like a fun dude with great zeal for life. Shouldn't pick on him. His compromise was a good one, especially we know that because that is what we ultimately adopted, and it's worked pretty well so far. From the Virginia plan, it takes the bicameral Congress and the idea of a Senate and a House of Representatives. The Senate would be the smaller chamber, and that's part of what also makes it the upper chamber. You can think about the House of Representatives and the Senate as clubs, and the Senate is the more exclusive club. And in the Senate, there will be equal representation for the states. It will be the system that we have. Each state gets 2 senators regardless of its population. Doesn't matter if you're tiny Wyoming or large Florida, you get 2 senators. The lower chamber with significantly more members, it's not immediately, obviously we don't have 100 senators because we don't have 50 states and we don't have 435 members in the House of Representatives. But even at this point, with fewer states and a smaller number of representatives, the House has a much larger membership. It's the less exclusive club. And here, the number of representatives each state will have is based on its population, not based on tax contributions. There will be a strong central government. So from the 2 plans, the New Jersey plan takes the small chamber with equal representation, that equal representation being kind of a nod to the New Jersey plan, whereas the fact that there are 2 chambers and one of them will be based on population and that we will have a strong central government, those are all pulled from the Virginia plan. And this is something that we will come back to later. But one of the things I want you to note from the beginning is that the Connecticut Compromise actually results in small states being overrepresented and having disproportionate influence in Congress. Because teeny tiny Wyoming has the same number of senators as California or Florida, New York, Texas. And that has consequences that really weren't fully explored by political scientists until the late 1990s. The second part of the equality controversy had to do with, all right, well, if state population is going to determine representation in the House, how are we going to determine state population? And this is, of course, leading us to the 3/5 compromise. Southern states wanted their slaves to count for population. Of course, remember that back in the days of the creation of the Articles of Confederation, the southern states had not wanted their slaves to count at all because population might have been the basis for determining how much tax each state owed to the national government. So when slaves being counted might cost them money, they don't want them to count. But now that slaves matter for determining representation, they do want them to count. which is a little more than a little hypocritical. Northern states, which at this time, all but one state had legal slavery, but most of the slaves are in the South. And so the northern states are opposed to counting slaves, not necessarily on moral grounds, but just on the grounds that it would boost the representation for the South. And of course, as I said, the compromise we get is the 3/5 compromise. Free persons will count as one person for determining representation. All other persons. The Constitution, if you pull up a PDF of it or pull it up online and do a Control-F search, you will find no reference to slaves. It is just all other persons. Count as 2/3 of a person. And under this compromise, population would determine, of course, representation in the House. But, and this was how the northern states thought they were extracting a compromise from the South, now slaves would also count for figuring any direct taxation of the states. So if Congress were to say, okay, states, you owe us, that's $1 per person in your population, and you have to contribute that to the national government. If that kind of direct tax was imposed, slaves would also count as 2/3 of a person for that calculation. Of course, this actually does not end up being some major concession by the South because Congress has never imposed any direct taxation of the states. So that part of the compromise never really mattered. And the reason there's never been such a tax really, doesn't have anything to do with slavery or opposition from the South. There's lots of problems in terms of how the Constitution was written and how such a tax would be calculated in the first place. And there have been Supreme Court decisions about this, and so there never ever has been one. Moving on from the equality controversies about primarily representation, there was also concern from the South about the slave trade itself. And more broadly about the Southern economy. Southern states were much more dependent on agriculture for their economies than the North. And agriculture in the North tended to be things like food crops that would be consumed in the United States. The South has a different agricultural economy. Theirs is based on cash crops like cotton and tobacco. And in this time period, cotton is not yet king cotton. Tobacco is the big deal of exports from the South. And the Southern states were afraid that the new national government would impose export duties, which would be taxes or tariffs on exports. And I know right now there's lots of talk about tariffs because Donald Trump has said that tariffs were the best thing ever invented, and he plans to use them. When we have that discussion of tariffs, we're not talking about tariffs on exports. We're talking about tariffs on imports. The southern states feared that there would be taxes on exports, which are really just, I actually can't think of a real-world example of taxes on exports or tariffs on exports. But the South was afraid that this could happen. because they knew this new national government was going to need money, and they thought it might get them by taxing the South's agricultural exports. And again, southern states, I mean, if you tax their exports and hurt that part of the economy, that could cripple them, because that was what they relied on. And they didn't have much manufacturing. They didn't grow. I mean, they grew some of their own food, but they focused on cash crops. They also feared, and this is the one that gets most of the attention, that there would be interference, particularly interference to hinder the slave trade. And by that they meant two things. One was bringing in slaves from other countries. Of course, primarily we're talking about importing slaves from West Africa, but they could also be brought in from places like the Caribbean or South America. They also were afraid that the national government might make it difficult to sell slaves across state lines, or even if a farmer were to move from, say, South Carolina to Georgia, that there might be some interference that would not let them take their slaves with them. The compromise for this, Congress made it illegal, I mean, constitutionally illegal to enact tariffs on exports. Okay, so that concern for the South was totally obviated. The slave trade did not get such a clear-cut, or did not provide such a clear-cut win for the South. And they just kind of kicked the can down the road. Said, look, national government's not going to do anything about the slave trade for 20 years, or until 1808. The only thing the Constitution did permit was that there might be a tariff or import duty on slaves that were brought into the country. But even that was limited. It was capped in the Constitution at $10 per slave. And $10 back then was a lot of money, but slaves were also very expensive. So $10 would not represent a tremendous share of the price of an imported slave. The political cartoon I've used for this is actually from much later, but it still captures the same idea. The idea was that the North would enrich itself at the expense of the South through taxes and tariffs on the South's agricultural economy. Now, got kind of some other matters to deal with. If you're thinking you're not giving us any time to read, that's kind of true. But some of these notes that I'm giving you now, I had originally intended you to get from the text, but I think it will be better if we cover them this way. Some of this will also be a bit of review. Remember, the big problems or area of problems under the Articles of Confederation was in the finances for the country and the states and even citizens, and broad economic problems. We already know about the trade wars between the states. They imposed trade restrictions and tariffs on each other. The Constitution settles that. There will be national control over trade policy, and states cannot impose taxes on interstate trade. So, I mean, that's done. And remember, the Great Compromise or Connecticut Compromise gives us a strong national government. So now when the Constitution says it, it's for real. So those interstate trade barriers will fall. We also have the issue of the debt crises in the early United States. We've kind of seen this from one angle. This will be kind of just to examine it slightly differently. Because previously, when we've looked at this, I mean, the debtors have kind of seemed like the victims of the national government and the state governments and bad policy. But the debtors themselves were part of the problem. They constituted majorities in a lot of states. And there were more debtors than creditors. And creditors, of course, are the people who lend money to the people who go into debt. And these debtor majorities were often very hostile to their creditors. And as an example of that, of course, we have Shays' Rebellion. But it wasn't just violent uprisings that were the problem. Debtors pressured state legislatures to create their own state paper money. And then, even though this money was basically had no value whatsoever, nobody wanted to accept the stuff. But the legislatures also forced creditors to accept those worthless state currencies as payment for debts. So it would be as if Parker had loaned Jackson $100, and then the state of Missouri said, all right, Parker, so Jackson can choose either to pay you that debt back in United States dollars, or he can give you monopoly money. Right? Whichever he gives you, you have to accept it as repayment of the debt. And under this situation, I mean, the creditors are losing their shirts, and they certainly don't want to give new loans. And if this wasn't bad enough, debtors often pressured governments to kind of break up debt contracts. And so, I mean, in that case, it would just be the government might say, we're just canceling debts. The early U.S. already had all kinds of problems with credit, partly because it had its own debts. The national government couldn't collect taxes. And this just made the United States as a whole less able to borrow money. The Constitution fixed this grab bag of mess in a few different ways. And it did it pretty specifically in provisions in the Constitution. It said, all right, states, you cannot intervene in a lawful contract. And those of you who, actually none of you has taken my law and citizen class, contracts, unless they are for something that is itself an illegal action, or are somehow fraudulent, lawful contracts are binding, and states can't interfere with them. They have to be upheld. And part of that is because the Constitution prohibits states from breaking up those lawful contracts. And it also said states, you cannot require that creditors accept paper money as debt repayment. If the debt contract says you have to pay it back in gold or silver, you have to pay it back in gold or silver. And you certainly can't force them to take it back in worthless state currencies. And to further help with this, the Constitution says Congress has the power to create a currency and that is going to be the only legal currency. States can no longer create their own monetary systems. All right, and finally, this especially gets at this problem, right? The credit troubles of the early United States in general. To prove that the new U.S. government would be a good borrower of money, right, from foreign countries and banks and such, the Constitution specifically says that the new U.S. government is obligated to assume responsibility for the old national debt and pay it off. Which it did. The third problem, I mean, it's related to these other things. Economic growth was just slow in the early United States, at least slower than it should have been. And so, in addition to mitigating problems of trade between the states and these credit and debt crises, the Constitution, in giving Congress the power to both call for taxes, levy taxes, but also the authority to collect them, now the national government has revenue. It can pay off that national debt and prove that we are a credit-worthy country. It can also improve the infrastructure in the country for economic development. That is not supposed to be a capital D. Development is not a proper noun. And I don't want you to get carried away with improving infrastructure. The Constitution's actually pretty limited on that. It talks about building, establishing post offices and building postal roads to connect those post offices. But still, roads connecting communities were a huge deal for encouraging trade and economic development. We also have the enumerated powers in Article 1, Section 8. You're going to see some of those in tomorrow's review assignment. Those gave Congress lots of powers. It is a laundry list of powers. One of those is, of course, to build those postal roads to help with economic development. Also gives Congress the power over copyrights and patents. And that protects, especially in terms of very concerned about patents. The United States at this time period, it's not generating a tremendous amount of art or literature that needs copyright protection, but patents are important. Once intellectual property is protected, people will invent things because they know they can profit from their inventions. Congress can also set uniform standards for things. I mean, this is the weights and measures. And these allowed Congress to overall improve the financial and business climate of the early United States. I'm going to hand you the text that you need on your way out the door. This is what you're going to be doing, and this is also in Canvas. And I know it looks like a ton of stuff, but it's really just so that you have details over what you need. You're going to get all of that information from pages 39 to 44 in this handout. All right, thank you guys for sticking with me till the end. So make sure you do check out those things in Canvas. You know exactly what